Real estate licensees are allowed to assist buyers and sellers with the preparation of 4 types of contracts: listing agreements, buyer brokerage agreements, sell and purchase contract, and option contract. Any other contract preparations by a real estate licensee is considered practicing law and is illegal. The statute of fraud requires certain contracts be written and signed by parties to be enforceable in a court. This includes purchase and sales contracts, option contracts, deeds and mortgages, lease agreements for more than 1 year, and listing agreements for more than 1 year. Take notice of the last 2 bullets. It's talking about lease and listing agreements that are more than 1 year. There's a question floating around out there that asks you which one of the following does not apply to the statute of frauds. They'll give you 3 that do, which is the first 3, and the one that's the correct answer that does not apply with the statute of frauds would either be a leasing agreement or a listing agreement for less than a year. They'll say 180 days, 9 months, something to that effect. Statute of limitations. That establishes a time period during which a contract is enforceable in a court. If it's written, it's 5 years. If it's oral, it's 4 years. Now notice they call oral contracts parole contracts, and a lot of times they'll refer to it in a question as a parole contract. They want to make sure you know that parole means oral. If you look carefully at the word parole, you can see the word oral. Now, in case they give you a question that says part of it's written and part of it's oral and ask you what the statute of limitations is, the time period, the written is 5 and the oral is 4, each portion accordingly. Elements of a valid real estate sales contract is remembered by the acronym COLIC. Competent parties, offer and acceptance, legal purpose, in writing and signed, and that's because of the statute of frauds, and consideration. The consideration is, what are you giving me for me giving you? Consideration is not referring to earnest money. There's a question floating around out there about which one of the following is not necessary to make a valid contract, and it would be an earnest money deposit. Yes, consideration is, but consideration is what the purchase price is. Void, voidable, and unenforceable. A void contract does not meet all the required elements of a valid contract and therefore has no legal effect. You might as well tear it up and throw it in the trash. Voidable contract, on the other hand, is a contract in which one party may cause the contract to be voided. They can get out of it without repercussions, and there's several reasons why a contract would become voidable. And then there's unenforceable. That's a contract with all the required elements, but it won't be enforced in a court of law because it doesn't comply with either the statute of frauds or it exceeds the time in the statute of limitations. Contract classifications. Contracts can be classified by their method of formation, their content, or their legal effect. Formal versus informal contracts. Formal is written. Informal is oral. Bilateral and unilateral contracts. Bilateral contracts obligates both parties to perform, and a unilateral contract only obligates one party to perform. Express and implied contracts. An express contract means that all the terms have been conveyed in words and a meeting of the minds is reached. Implied contracts, they're not necessarily expressed, but they may be reasonably implied. And the best example of this would be when we go into a restaurant, we're seated, we have a meal. we are expected to pay. It is implied that we're going to pay for our meal. We didn't stop and talk to the hostess or the manager and say, look, if you feed me, I'll pay the bill. Okay? It's implied. You sit down, you eat, it's implied that you're going to pay. Executed and executory contracts. An executory contract is a contract that is in the process of being carried out. Still got things to do. It's not closed yet. An executed contract is one that's been closed. Everything's been done. It's been carried out fully. It's closed. Everybody's happy. Buyer's got a house. Seller's got money. Agent's got their commission. It's over and done with. Contract negotiation. An offer shows the intent to contract. You have an offeror and an offeree. In the beginning, when an offer is put in on a property, the buyer is the offeror because they're giving the offer, and the seller is the offeree because they're receiving the offer. Now, if the seller decides to make a counteroffer, the seller now becomes the offeror, and the buyer becomes the offeree because the buyer's receiving the counteroffer from the seller. Now, the counteroffer also alters the term of the original offer and kills the original offer by substituting a new offer. Ways an offer is terminated is remembered by the acronym WILDCARD. Withdrawal by an offeror, insanity, lapse of time, death, counteroffer, acceptance, rejection, or destruction of the property. Ways contracts can be terminated. By performance, everybody does what they're supposed to do. Mutual rescission, both change their mind. Impossibility of performance could be the survey didn't come out what it needed to come out and the seller's not willing to reduce. Or maybe the buyer wasn't able to secure financing. Lapse of time or breach. There are 4 remedies for breach of contract. Specific performance. That's where the court orders the party who committed the breach to perform as stated in the contract. The judge says, get it done, period. Liquidated damages is given if the buyer defaults. The seller may retain the deposits as liquidated damages. Liquidated damages means it's damages that you can touch. Okay, so the earnest money is truly sitting in a trust account. It's there, it's accessible. And because of that, it's referred to as liquidated. So that's what liquidated damages are. Rescission is the cancellation of a contract and the parties are restored to their original position. So the judge says, look, I'm just tearing up the contract. You guys go back to the way you were originally. It's done. That's rescission. Compensatory damages are known as unliquidated damages, unlike liquidated damages. The money's not there. It's not touchable. So what happens if for instance, a seller, the buyer breached the contract and the seller's out a significant amount of money and it's more than what's in the earnest money deposit. So there's additional damages that the seller has incurred. The seller can go and sue in civil court and be awarded the difference in the monetary damages suffered because of the breach. If that happens, that's what's referred to as the unliquidated damages because it's a judgment. And the seller's just got to hope that the buyer comes through with the money at some point in time. Assignment and novation. Assignment occurs when one party transfers rights and duties to another person. Again, you've got ors and es here. You've got an assignor and an assignee. Novation occurs when a new party is substituted for one of the original parties. And what happens then? If novation occurs, the original party is no longer responsible. If there is not novation, then the original party who assigned whatever it is, let's say it's an apartment lease, assigned an apartment lease to a new person. If there's no novation, if that new person does not pay the rent or destroys the property, the original person's still responsible. However, if novation occurs, then that's when the original person would not be responsible. A listing contract is an agreement between the owner and the broker. Listing contracts may be written, oral, or implied, and a sales associate's authority is derived from their broker. So watch out for the question or scenario that you might be given that talks about the agent goes out, presents a CMA, takes a tour of the property, puts the sign up, gets the signatures and everything, and then they ask you, who is the person who contracted with the seller? They'll give you the broker, the agent, and then two other ones that you know that you can just throw out. So you're between the broker and the agent. You're thinking maybe it's the agent because they went out there and did all the work. It's not true. The broker is who contracted with the seller. Even though it was the agent that went out there to get the physical signature, it's the broker who contracts. The broker is in charge of everything. Okay? So anything that happens within the brokerage, the broker is responsible for, and the authority is derived by the salesperson from the broker. There are two conditions created by listing contracts. One is find a purchaser and one is effect a sale. They both sound basically exactly the same with one difference, and that's the effect of sale. So I'm just going to read it to you, and then I'll explain what the little difference, which is really a main difference, is. So to find a purchaser, the broker must produce a buyer who is ready, willing, and able to purchase at the terms of the listing contract or at other terms that the seller accepts. Simple enough. Effect to sell says broker must produce a buyer who is ready, willing, and able to purchase at terms specified or accepted by the seller. Same things, right? Except for with effect to sell, it says must ensure transaction closes. So the only way a brokerage gets paid on effect to sell contract condition is if it closes. On the other hand, if the condition is just to find a purchaser, if the purchaser is found at the terms of the contract and the seller all of a sudden says, I don't want to sell, I'm taking it off the market, the seller still owes the commission because the brokerage did their job. They found that buyer who was ready, willing, and able to purchase at the terms. Types of listings. You have three main types of listings. You have an open listing, which is basically your for sale by owner. It's a unilateral contract, and it's where for sale by owners agree to cooperate with real estate agents and brokerages that if they find the buyer and they bring it to close, the for sale by owner is willing to pay a commission. Those cannot be put in the MLS. Exclusive agency listing and exclusive right to sell listing are basically the same listing with one major difference. Both of those can be put into the MLS. The main difference is that in the exclusive agency listing, the seller retains the right to locate a buyer themselves and not pay the brokerage the listing commission. Brokers don't like that one. Okay, especially now with the internet and how quickly signs go up and everything. More than likely, even if someone goes and knocks on that owner's door and the owner shows them the house, negotiates the terms without the agent involved, the agency, the brokerage, was still probably the procuring cause because it went on the internet, a sign went up, etc. The type of listing that a broker prefers is the exclusive right to sell listing. Exclusive right to sell. The way to remember that one is the broker likes the right one. The broker's going to be paid a commission regardless of who finds the buyer. And then there's a net listing. Net listings, they can be open, exclusive agency, or exclusive right to sell. This is a listing where the broker retains the proceeds in excess of the seller's net. So what happens in this instance is the seller states that they want a net amount at the closing table and tells the broker that they can sell it for whatever they want and keep the proceeds in excess. It's illegal in a lot of states for net listings. It's still legal here in Florida, but it is frowned upon because of the propensity of fraud. Most of us know what the multiple listing service is. It's a cooperative service between brokers. Listing information may be entered into the service with the owner's permission. So catch that, with the owner's permission. We actually have to have the owner's permission to put it on the MLS or let it upload to the internet. Participants in the service, even from other brokerage firms, they put in properties where the properties can be showed, and then if the buyer's agent sells the property and it closes, then the buyer's agent receives a commission. Statute 475 has some certain written listing requirements. And contracts must include a definite expiration date, description of the property, listing price and terms, the broker's compensation, whether it's a fee or commission, signatures of all the sellers. A copy has to be back to the sellers within 24 hours. That's not one business day. That is a true 24-hour period. And automatic renewal clauses are prohibited in listing contracts. Buyer brokerage agreement. It has the parties and the terms of the agreement, the characteristics of the property desired, the broker's obligations, the buyer's obligation, compensation including any retainer if applicable, protection period, early termination, and authorized broker relationship. With sell and purchase contracts, you have a vendor and a vendee. The vendor is the seller. The vendee is the buyer. It is a bilateral contract, and it's in writing and signed due to the statute of frauds. Power to bind the seller or the buyer. The broker doesn't have the authority to sign for or bind the buyer or the seller. Only a power of attorney will give someone that ability. That is a document that designates another as attorney in fact. Disclosures. Sellers of residential property must disclose material defects. Johnson versus Davis is the Florida Supreme Court decision. As is provision does not circumvent the duty to disclose. The seller still must disclose what's wrong with the property. They don't have to fix it, but they do have to disclose it. Radon gas disclosure is required. It's a statement on the sale and lease contracts. It includes lease contracts. It has information regarding radon gas, but it does not require testing for the sale or lease. Lead-based paint disclosure applies to housing built before 1978. Homes that are built prior to 1978, sellers and landlords, again, lead-based paint covers leasing. must disclose presence of any known lead-based paint. Contracts and leases must include disclosure about lead-based paint. Buyers and renters must be given an EPA booklet. Sellers must allow buyers to conduct an inspection within 10 days. However, the inspection is not required. Now, watch out for a question floating around. They talk about this 10-day inspection period, and the question is worded where it's saying that the seller has to pay for the inspection if the buyer requests it within 10 days. That is not true. The seller doesn't pay for the inspection. All the seller is required to do is allow the buyer to do the inspection at the buyer's cost. And then there's contractor requirements now since 2010. Contractors have to be specifically certified and follow specific procedures in order to disturb lead-based paint. Florida Building Energy Efficiency Rating Act. Buyers before signing sales contract must receive an informational brochure stating that the purchaser may get an energy efficiency rating. This created uniform, statewide energy efficiency rating systems. Homeowners Association disclosure. Properties that are subject to a mandatory homeowners association must provide buyers with a disclosure regarding the association, fees, restricted covenants, and assessments. There is a 3-day right of rescission that cannot be waived, but it does end at closing. The property tax disclosure. That's a disclosure summary concerning ad valorem taxes. Ad valorem means according to value. Before or at the time of execution of a contract for sale. It states that buyers should not rely on the amount of the seller's property taxes as an indication of the taxes that the purchaser will be required to pay in the year following the purchase of the property. That is because properties are normally reassessed and the taxes could go up or down depending on a myriad of factors. Did the original owner claim homestead? Is the new owner going to claim homestead? There's a lot of factors that are involved. Building code violation disclosures. Sellers must disclose. They need to disclose the existence and nature of the violation, provide copies of the pleadings, notices, etc. And the buyer needs to know that they'll be responsible for compliance with the code. The building code gods, they do not care who created the problem. They care who owns the problem. And along with all that, the seller must forward the name and address of the new owner to the code enforcement agency within 5 days. Community Development District Fee. And this is a disclosure as well. Okay, it's also referred to as a CDD fee, and it shows up on the property taxes. What it is, and it's not a property tax like an ad valorem, it's not according to value, it's just an additional tax like a special assessment shows up on your property taxes. What it is an independent special district that services the long-term needs of its community. It constructs, operates, and maintains infrastructure and services. The developer finances the construction of the infrastructure by issuing bonds. Then the homeowners repay these bonds through tax assessments. Written disclosure in initial contracts for sale must disclose if a property has a CDD fee attached to it. When selling timeshares and listing timeshares, there is a required disclosure. And it requires that the disclosure state that the agent is not guaranteeing a sale. Some other requirements are the commission and the fees, the terms, the broker services, termination rights, judgments or litigation against the broker for consumer fraud, and the buyer has a right to cancel within 10 days. Puffing, misrepresentation, and fraud. Puffing is the exaggeration of a property's benefits. Let's say I have a ditch in the backyard, has water running through it all the time. Not a lot, but sometimes when it rains it has more, and I want to call it waterfront property. Is there water in my backyard? Yeah. Is it really waterfront? Nah, so that's a little bit of exaggeration. Misrepresentation is a misstatement, omission, or concealment of a factual matter. Kind of like lying. All right. Fraud is the licensee made a misstatement. The licensee knew the statement was not accurate. The party relied on the misstatement, and the party was damaged as a result. Now, if you get a question with a big old long scenario and they want to know if it's puffing, misrepresentation, or fraud, the only time you would pick fraud is if there's monetary damages as a result of the misstatement.